Alex here with an event video on the Mildred Kellman Self-Declaration Trust, our first peek into a trust dispute. A mother of 6 formed the trust in 1992, the latest provision of which provided that upon her incapacitation or death, her son Michael and his sister Joy were to take over as trustees. The petitioner, Michael Kellman, accuses his sisters, Joy and Sherry, of duping their mother via fraud and undue influence into transferring one of the trust's properties into their names as a joint tenancy. In compliance with the court's order, the property was returned to the trust via quitclaim. Shortly thereafter, their mother died, after which Michael raised new accusations against Joy for abusing her authority as co-trustee, refusing to facilitate the sale of the home, and living there rent-free. Michael sued, demanding his sisters vacate, that Joy reimburse reasonable rent and other expenses to the trust, and for an order allowing him to unilaterally sell the home. He also demanded enforcement of a settlement agreement entitling him to reimbursement of $125,000 in advanced attorney fees. Joy and Sherry responded, calling Michael's efforts yet another attempt to disparage them and denying the allegations. Joy specifically admitted to spending hours at the home on a daily basis, but said she was only doing so to prevent the property from appearing abandoned. District Court Judge Gloria Sturman allowed comprehensive electronic coverage of the proceedings, the first 2 hearings of which we have already recorded and will publish shortly. Michael Kellman is represented by Douglas Gerard. Joy and Sherry Kellman are represented by Dana Dwiggins. You can keep up to date with our coverage schedule by visiting ournevadajudges.com, and you can feel free to post any questions or comments you have down in the comments below, or by sending an email to media@ournevadajudges.com.
To go along with that purchase price, and they're willing to say on the record that that is acceptable to them, then my client's fine going forward with that. That doesn't resolve the issue that Your Honor started to talk about why it takes a year and a half and why she needs to spend 6 hours a day at the property for a year and a half. I mean, that's not managing the property. That's not taking care of the property. That's just spending her time there that she could spend somewhere else. And I think that's frankly been one of the reasons why there's been a delay.
If she go to Starbucks, but what difference would it, what difference would it be of your client? This is what I'm saying, is why does your client care? If she does this at the library, or at the local Starbucks, or at this house with the trust owner?
It only matters if it's delayed.
Matter?
It only matters if it's causing a delay in getting this property sold and moved forward. Okay. And that's what we think is failing out.
I don't see any reason why she's hanging under this property so she can go there for 6 hours a day. Sounds to me like all of these disputes have been, no offense, people just need to move on. By which I mean your respective clients. You had resolved this matter months ago. Council had been very diligent in getting all of these issues resolved, but doing everything you need to do for your clients has resulted in these disputes over these less significant issues that now are just festering because it's the last thing that's left. Now we have this house left. We've got all these other things resolved, so now let's fight over whether or not you've been spending time there by asking neighbors if you see them coming and going. These people just need to get on with their lives, and this isn't helping. They have this case resolved. They need to just move on, and